It's a little faint, I would say.
Okay.
Better?
Yeah, say some more.
This is Jenny. I just unplugged the headphones. Is that better? Donna's
Yes.
nodding.
Okay.
Yes. So here's what I'd like.
But now we're hearing a lot of feedback, a lot of echoes.
So
I can close some of the other things on my screen if I need to, but what I wanted to do was to say, this is an unusual meeting and I need to call it to order. It's going to be live streamed. And I know that there's a conversation that was going on about which document. What I'd like to do is to frame that issue and to explain to the committee and to members of the public how we are proceeding and what we're doing. And I think it's unusual for this committee, but it may be that we are not going to be sharing documents in the same way that we usually do, but I will explain why. So Lyndon, I think your questions will be answered and other people's questions will be answered.
Okay, I have a note from Josh that he is ready to start the live stream at 5:30.
Okay, at the moment, we only have me. Oh, we have me and Gina. Let's see. Let me look at, I was looking at chat. So the members of the committee are me, Gina, Tom Croto, and Chuck Crush. At the moment, we just have me and Gina. It looks like we also have Liza Poinier. So Liza, would you be willing to be appointed a member of the committee for this evening's purposes?
sure.
Okay, and again, we haven't formally started. I don't believe we started streaming yet. Let me give it another minute and see if we have another committee member join. And then we'll start, and I can start with the emergency meeting statement and then move into kind of the background information. And then Karen, I think just presenting the high level bullets will probably make sense. So if anyone is having trouble hearing me, just signal to me, because I want to make sure, since it's being live streamed, that I am intelligible. Is it better with the headset off?
Yes.
Yes.
Yes, it is much better than it was.
Okay, great.
Jenny, have you tried wireless earphones?
I've had trouble with them in the location that I'm in right now. So yes, and I have them, but they haven't worked. They've worked less well than the wired ones. But I think this should be fine as long as we don't have a big thunderstorm or people tearing through the space I'm in. But
yeah.
If that happens, I'm sure everyone will forgive me, so it will be fun. I'm wondering whether it would be possible for someone, Donna, maybe you, to resend this invite to Chuck and Tom to make sure that they remember.
I'll do that right now.
Okay.
Annie, do you want me to call them?
Sure, Gina, if you want to text them or call them and just make sure that they know we're meeting, that would also be. I know there is just so much on everyone's plate with the forums and everything.
I can call Chuck. It'll take me a minute to look up Tom's number, but we are now streaming. So.
Oh, okay. Well, let me kick off the meeting and hopefully we will. I think we have enough if we appoint Liza to go forward with this, and I would like to do that. Okay, good evening, everyone. It is July 29th. It is 5:33 p.m. I'm Jennifer Patterson. I am calling to order a meeting of the Communications and Policy Committee of the Concord School Board. And first, I'll read the emergency meeting statement. As chair of the Concord School Board's Communications and Policy Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. The business we intend to conduct today is necessary due to the need to review proposed changes to the district's sexual harassment policy that are necessary due to a change in federal law that takes effect on August 14th, 2020. Please note that there is no physical location to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, we are providing public access to this meeting by telephone with additional access by other electronic means. We are using Microsoft Teams for this electronic meeting. All members of the committee have the ability to communicate contemporaneously during this meeting through this platform, and the public has access to contemporaneously listen and, if necessary, participate in this meeting by dialing the phone number 925-391-1169 with a conference ID of 542-494-58#, or by clicking on the link that's provided on the SAU 8 website, or by watching the meeting on CCTV's YouTube channel, and a recording of the meeting will also be posted on CCTV's website. The committee does not intend to take public comment during this meeting. We do encourage the submission of citizen comments via email at concordinfo@sau8.org. We gave notice to the public of the necessary information for accessing the meeting, including how to access the meeting using Microsoft Teams or telephonically. The meeting and pertinent instructions were posted on the website of the board at sau8.org more than 24 hours prior to the meeting and are highlighted at the top of the website. If any member of the public has a problem accessing the meeting as we are meeting, please call 603-513-9008. And in the event the public is unable to access the meeting will be adjourned and rescheduled. So first, I'll take a roll call attendance of committee members. All committee members will be participating remotely, and any votes that are taken during the meeting will be done by roll call vote. When each member states their presence, please also state whether there is anyone in the room with you during the meeting, which is required under the right to know law. Please mute your microphone when not speaking and wait to be recognized. And now I will stop reading and look and see whether we have any additional members. Looks like not yet. So I will take the roll call. Ms. Cannon, are you present?
I am here. I'm alone, but there may be someone that pops in at some point.
Great. Thank you, Ms. Cannon. Mr. Croto, are you present? So I believe Mr. Croto is not present. Mr. Crush, are you present? And I believe Mr. Crush is not present. I'm Jennifer Patterson. I am present. I am presently alone. It's possible, as with Ms. Cannon, that someone might pop in. And I had planned to look to see what other board members were present. I know Ms. Poinier has called into the meeting, and I will ask if she's willing to serve as a member of the committee for this evening's meeting. So Ms. Poinier, are you present and are you willing?
Present, alone, and willing to serve.
Great. Thank you so much, Ms. Poinier. So we do have a quorum of the committee. I believe there are not any other board members who are present at this time. Ms. Murphy, if you could just introduce the district staff who are present, that would be helpful.
Oh, thank you. With us tonight is Donna Pally, our Assistant Superintendent for Schools, and Karen Fisher Anderson, our Chief Safety Officer for the district.
Great. Thank you. Thank you all for participating. And I know this is a really, really busy week because we're focused on school reopening. So I hope that this will be a very focused and hopefully brief meeting. And I just wanted to first give a little bit of an overview of what this committee is, how we typically operate, because Ms. Murphy, Ms. Fisher Anderson, and Ms. Cannon are all pretty new to this policy committee. So typically what we do is we're the committee that reviews really word by word policies before they're adopted. And we go through and we kind of wordsmith and we talk about the policy considerations. And then as a committee, we make a recommendation that the full board consider a policy if it's a policy that we feel should be adopted. And once that recommendation has been made to the board, it's posted on the agenda and the full language of the policy appears in the board packet. And the first time it appears, it's called the first reading. And so the board will talk about the fact that the policy is being considered, but they won't vote on it. Then at the next monthly meeting, there will be the second reading, and that is when typically a vote is taken on a policy. And so Gina, you have your hand up, so let me stop. And did you want to add something? No. Okay. So typically that's how we proceed. And I think it's important to give a little background on this particular policy that we're looking at tonight, which is the sexual harassment policy, just because it is one of the policies that we as a committee, as a district, as a board spent a lot of time reviewing last year. So starting last spring, the district and this committee undertook a very detailed review of student safety, sexual harassment, reporting, lots of policies that were related to the Howie Young situation that had occurred. And so we as a committee met in May and June, and then in July, we had 2 forums that focused on 5 areas of policy that were related to those incidents that included community members, including Ms. Cannon as a community member before she was on the board, as well as experts. There were a number of policies that were brought forward last August and adopted in an expedited fashion without the second reading because of the importance of getting them in place. There were some other policies that we needed to take more time with, that we circled back and had additional meetings in September. There was one policy, the employee student relations policy, that we spent a tremendous amount of time with. We had a great process that involved students, that involved staff, and that policy was adopted in March by the full board. And our intention had been that after we got through our budget process, we would return to looking at some of the policies, including the sexual harassment policy. That unfortunately did not happen on the time frame that we had hoped to do it because of COVID-19. We had hoped to do it in April. At this point, I think that continued work, kind of the follow along with what we've been doing over the past year, will be happening in September. And so at the end of today's meeting, we can talk a little bit about kind of the time frame for that continued work. What we're doing tonight is a little bit separate. What we're doing tonight is looking at changes to the policy that are specifically required by a new federal rule that takes effect on August 14th. And it requires school districts to adopt very specific new standards. And so Karen Fisher-Anderson, and I'm about to turn it over to Karen, our student safety compliance officer, has been working diligently with the New Hampshire School Boards Association, the school attorneys group, on developing a model policy that incorporates all of these changes that are required by this very specific federal law. So what we're planning to do tonight is to look at what we need to do to come into compliance with that law. Now, there may be, and we will probably hear, some additional things that we as a district want to do, perhaps that relate to the ongoing policy work that we have done, but our primary focus today is just on making sure that the district is in compliance with the law. The other thing that's a little unusual is we don't have a version of the policy to go through line by line the way we typically do when we meet as a policy committee, because it is still in draft form and there are changes that are occurring even this week. And so Karen's going to talk with us about that and just tell us what are the key points of this policy, what are the key points that she feels are appropriate for Concord to include. And if it is her recommendation, I'll ask the committee to vote to send the model policy to the full board so it can be considered and adopted at the August 3rd meeting. And again, with the goal of just complying with federal law. And that, again, it's unusual. We would retain our ability at a future meeting of both of this committee and of the board to make further changes to it, but we also don't want to be in the position of not being in compliance with federal law. So sorry about the long-winded explanation, but hopefully it's helpful so that folks understand that this is a very specific conversation. It certainly does not preclude a conversation that really is more consonant with the way that we had envisioned the work of this committee going forward. That will still happen, but it won't be at this meeting. It'll be in September. So with that, I will turn it over to Karen Fisher-Anderson. Thank you.
Thanks, everybody, and good evening. Lyndon asked me about what specific document I was going to be referring to, and I sent out this morning what is marked, well, it's our third iteration. When I say ours, mostly the New Hampshire School Board Association. Will Phillips is the attorney, the policy writer. And so what I did is I took his policy, which we all worked on together, and then I went and I personalized it with some additional information and some other things I think are important to include that I will be just mentioning as we go along. Unfortunately, this afternoon at about 1 o'clock, I called Will on a couple of questions I had just to be sure we were all on the same sheet of music, and he informed me that he has got yet another iteration, but he did tell me that the substantive information is pretty much the same. There's some format changes, etc. He sent me a copy of that policy. I'll be honest, I didn't have a chance to look at it after I worked mine. And so my goal is to brief you all, give you the bullets where I think we can do even better than what the model policy is going to be. And then I'll work with Lyndon to make sure we can incorporate, if you all like my recommendations, we can incorporate those, into the model policy that we're going to see probably by Friday, and that you all will have a chance to read line by line if you so desire. So with that said, I will go ahead and get started. There are a couple other references that I'd like to just direct your attention to that I think will be helpful in understanding where I'm coming from. Specifically, if you take a look at ED 303.01 when you have a chance, obviously you all are probably really familiar with that because it's the substantive duties of the school board. And if you look at paragraph J, that is what I'm using to help guide what I'm putting into our district's policy. And specifically, it mandates that you establish a policy on sexual harassment written in age-appropriate language and published and available, and you'll read all this, but it has to be published and available in written form, and it has to be to students, to parents, to educators, to whoever may be interested in reading the policy. Specifically, it then goes on and it has 9 directives within paragraph J, and I've made sure that our policy and the recommendations that I'm putting forth address all of those. First of all, you have to have a statement that that sexual harassment is against district policy. You need a definition of sexual harassment with examples, the name and the roles of persons involved in implementing the procedures, description of the processes and timeframes, deadlines for investigation and resolution, a prohibition against retaliation, description of possible penalties, including termination, a requirement that a written factual report be produced as part of the investigation, a level of appeal, a statement that someone can bypass the internal process and go directly to the New Hampshire Commission on Human Rights, and the information on how to do that. And so all of that, as I said, is outlined in 303.01. Now, Concord School District, as I know you all know, has policies with regard to non-discrimination for the school board, which is 160, I believe. You have one for personnel, which is number 412, and you have one for students, which is number 571. You also have a school district policy and 631, excuse me. Those are the non-discrimination. And then, of course, you have a sexual harassment instruction, which I have become extremely familiar with, which is number 521. Unfortunately, fortunately, what we're going to do with Title IX is not the same as what you've already done in the other policies. That's good news. The bad news is that some of the things that we're going to do in order to be consistent are going to require that we modify the previous policies that I've just enumerated for you. I'm already working with Will on those, and we will continue that. And so I don't expect that's going to happen by Friday. I think we just need to slow down because you all have an awful lot on your plates. But please know that I'm looking for the consistency between our policies. So those will be updated, as I said. Now, I apologize. I'm sure many of you probably already know this, but in case nobody does, I just want to put it out there that this new Title IX policy that came down from Secretary DeVos from the Department of Education pertains only to sexual harassment as contained and listed as a form of discrimination on the basis of sex. Okay, it's very, very specific. When you look at suspect classes and you're looking at race, marital status, disability, and all those things that normally fall under a discrimination policy, those aren't included in this particular policy and grievance process that I'm about to brief to you. It is specifically and narrowly tailored to sexual harassment, and it deals with sexual discrimination on the basis and sexual harassment on the basis of gender, gender identity, and gender orientation. And when it involves an educational program or activity for an institution such as the Concord School District that's receiving federal funds. So there's a couple of buzzwords there that I just wanted to put out to you because I'll be referring to those later on. Unfortunately, Secretary DeVos has been inflexible she's had many groups, especially victim advocacy groups, and there's several lawsuits pending that have requested that she extend the date for the implementation of this policy, especially in light of COVID-19 and return to schools. And her response in one of the pleadings was simply that you've had 2 years to get used to these rules and you need to implement them. So good news is we're going to be ready on the 14th if you like the policy. The bad news is, as I said, there's going to be, in addition to putting the policy up on the website and some other areas that I want to talk to you about, there's also going to be the need for me very specifically to make sure that the policies are posted in appropriate areas, to make sure I continue to do training and awareness, which I've already started doing, but it's going to continue, and we need to make sure that I do that appropriately, and I'll do it to as many times to as small or as large an audience as we need to. And then the reporting requirements are just really, really important, as they have been in other policies, and I'll refer to those later on, but we have to make sure in our training that I make it very, very clear that what the reporting requirements are under this Title IX policy, in addition to our mandatory reporting requirements to DCYF or abuse and neglect, to law enforcement agencies under the Safe School Act, et cetera, et cetera. So there's a lot going on. Yeah.
Sorry, excuse me. Can I jump in for 1 second? Just
Sure.
2 things. First, Tom Croto has now joined. Welcome, Tom. And you missed my lengthy preamble, but I wanted to recap it just in a quick sentence, which is, this is an unusual meeting because it pertains to the sexual harassment policy, which is one of a number of policies that we spent a significant amount of time on last year, that we adopted new and revised versions of last August, and that we have expressed a commitment to continue to revise and to talk with the community about in light of the whole Howie Leung situation. These changes that we're talking about today don't directly pertain to that initiative of the district. They pertain to specific changes that are specifically required by a new federal rule that was put out by Secretary DeVos that takes effect on August 14th, and that we must, in order to retain our ability to receive federal funds, be in compliance with. However, they will require that we go back and look again at all of those policies that we looked at last year, not with a view necessarily to improving student safety, but to making sure that we're consistent with the federal law. And so we're trying to do both of those things at once, but really what we're doing today is trying to get a very basic understanding of what the changes and the policies to comply with the Title IX rule are. And it's going to be an unusual meeting because we don't have a real version yet of the policy itself. So there is a version that's been available to board members, and should this committee vote to send this to the board for our August 3rd meeting, it'll also be made public to the public, but it's still a work in progress with the School Boards Association, so that's why we're not working through it in the way that we usually do, and instead we're hearing basically an overview of it, and then we'll have a conversation as a committee as to what we want to do given the situation. And while I'm interrupting, Gina, you did have your hand up, and so I wanted to call on you if you had something to add or you had a question.
Let me just say thank you, Jennifer, for that. And I'm sorry to make you go through it all over again. But as we all know, these policies are living documents, and so they'll require change as we know that everything is seemingly needing change. So thanks.
Also, Liza has agreed to be a member of the committee for today's meeting. So thank you, Liza. And Gina, go ahead.
So I'm writing notes, but I needed to ask Karen if she could run through the ED 30601, I'm assuming Roman numeral lowercase I, and then which of the policies are directly affected? You ran through that really quickly and I couldn't take notes as fast as you were speaking.
Sure. Well, I'm looking at the 303.01, and that's the authority for the 303.01, substantive duties of the school board. And then if you go to subparagraph J, what I'm looking at, and it talks about the policy and language, and then it goes through talking about sexual harassment, and there's about 9 different detailed things that you are responsible for ensuring your sexual harassment policy contains. Have you seen?
Okay. Yep.
Okay. So
I've
that's
got
the
that on
first one.
another tab. Yep.
Okay, good. The policies at this point, and there's probably going to be a couple others, but the policies directly at issue are all of our non-discrimination policies currently up on the website. And I can give you the numbers. They're 160, 412, 571, 631, and then our sexual harassment policies, which are both it's 521 is the real long one, but also there's the 414, which is the list of investigators, which I've already recommended changes on to Linden based on some new personnel. But those are the ones that are immediately identifiable. And again, we're working as a group with a school board committee to identify them. Will has a weird numbering system, I'll be honest. I'm still working my way through that, but I'll make sure there's consistency between what we're recommending in our policies to the maximum extent possible, because remember, what we're doing under Title IX is so narrowly tailored to just the sexual harassment component for programs and activities in a school that receives federal funding.
Thank you. I just, as a retired attorney, I'm trying to follow where the circuitous back and forth. So
no, thank you. And please slow me down as you all need to. I know this, I've been working on this stuff, but I want y'all to stay awake too. So if you start looking at your policy, you'll see that first page is just the adoption notes, and those, I'm just going to ask you, you can read them, but we'll deal with those. The new adoption notes that are coming out in the iteration I talked to Will about today will be shorter, and those won't even exist in our policy. So what happens is the first number 1 is the policy prohibiting discrimination on the basis of sex. I opened up the policy and I started working on this, and then I went back to the fact that this policy is supposed to be reader friendly to students, to educators, to parents. So my recommendation, and it'll be included in the final draft you see, is that we open with our Concord School District mission, which I took a look at and pretty much pasted it into the document, and said that consistent with this vision, that all students and employees have the right to learn and work in the safest possible academic environment and in a workplace free from sexual harassment. And then I briefly defined the portion of Title IX of the Federal Education Amendment Act that pertains specifically to the sexual discrimination we're working with. So I think we need to educate our readers a little bit instead of just jumping in and saying, hey, sexual harassment is prohibited. I think they need a little bit of background. That'll be up to you all to decide if you like that approach, but it's in there in my policy. So the policy actually, as you start reading into it, obviously, number one out the gate says, we prohibit discrimination on the basis of sex, okay, including sexual harassment. And then this policy applies to, and it tells you who it is, all students, employees, and third-party contractors within the district who provide services to students and employees, so on and so forth. So that paragraph kind of gives you the jurisdiction of who it applies to. It also applies to employees or prospective employees who are seeking employment. And so I included a little bit on that as well, because again, this policy applies to just students and employees. And there's a lot of, I wish we could have separated them, but we couldn't. It's very student heavy. It's not as heavy for employees, but that particular specific guidance I think is important. So I made an addendum there that you'll see. Then really what's important as we go on are the instructions on how to make a report. And please note that a report is separate from a formal complaint. So initially we'll get a report, and then I will follow up, more to come on that, and then a decision will be made by the potential complainant on whether they want to file a formal complaint. So number 2A here, if I'm on the same page as you are, is just the application of the policy. It's pretty boilerplate language. Again, what I've already told you about on who it applies to. There's some limitation language in there, and that nothing in this policy will confer on any third party a right to due process or other proceedings, blah, blah, blah. That really pertains to, say, volunteers. Initially, I thought, geez, I wonder if we should include the volunteers in our policy. But when we talked about it in more detail, we felt that it was really important to train the volunteers, but not necessarily include them in our policy. If we do that, we're giving them due process rights, which my recommendation is we keep it limited to the students and employees and third-party contractors. Okay. So that's pretty much what we're getting to on the sexual harassment prohibition there. Congratulations, Kathleen, as the superintendent. You have overall responsibility for the implementation of this policy, and there's guidance to you that says, hey, every year you need to specifically appoint a Title IX coordinator, and it has to include the name, contact information, duties and responsibilities. And then that'll pertain to a couple of other board policies. But that's another really important piece that I think we'll be able to get on right away, and that is making sure we're getting notice out to everybody that, hey, we have this Title IX policy, and I'm your Title IX policy coordinator. We're doing posters. We're going to post this policy once approved in the student handbooks. I would like to do a video for our website for those people who don't want to read through a 24-page policy. I don't really like it. I don't think they will either. I also want to do a question and answer for some of them. But anyway, I digress. It just has to specifically identify the Title IX coordinator for students, for parents, for third-party contractors, and also, believe it or not, for union representatives. So I'll be getting in touch with them once we have our policy and just saying, hey, I'm me. If you have any issues, let's talk. Okay.
Let me stop you for a second because I think Tom has his hand up. Or Lyndon, you have your hand up. Did you have something first that you want to say?
Yes, thank you. I just wanted to point out to everyone that the number of non-discrimination policies, 160, et cetera, they are all exactly the same policy. They just have different numbers and are placed in our policy section in different areas. if they pertain to general staff or to students, but the language is exactly the same. Thanks.
Thank you, Lyndon. Tom?
Thank you. Karen, just a
Yes.
quick question before we move further from that policy. When we had our discussions with our board members and our committee members and our parents, we talked a lot about to whom we should these reports are going to go to. And one of the concerns that was brought up very strongly, you know, given in light, I think, of our situation that had happened in the past, that people are able to report to anyone and everyone just about, and not just to the principal. And mostly that the principal doesn't have the final say on whether something moves on or not. So is there something still in that policy that that recognizes that philosophy?
Yes, yeah, you're right on track, and you're a little bit ahead of me, but I promise I'll address that. And if I don't answer that specifically, please ask me again. But yes, and I understand what you're saying about the recent redaction and release of the investigation. I've thought about the possible chilling effect that may have on internal personnel practices and release of records. Unfortunately, the research that I've been able to come up with is that you hope that employees will cooperate for the welfare and safety of students. However, if they choose not to cooperate, we cannot bring any disciplinary action against them because it's viewed as retaliation.
Sure.
So that's one point, but I will continue. And Tom, if I don't answer, please let me know.
No, that's fine. And thank you. I just want to be sure that we get through that one roadblock that we heard so very strongly, that you know, that the buck stops at the principal's office. Thank you.
No, this process, when you go through the grievance process, you're going to be like, holy moly. So, okay. All right. The next section has to do with definitions. And like any kind of federal policy, this policy is extremely heavy on definitions. One of the schools that I looked at had a 6-page definition section. We took a look at this as a subcommittee for the school board model policy, and Will included, he included the ones that are in black: actual knowledge, complainant, decision maker, determination of responsibility, and the ones that are listed there. I also am recommending, and you'll see that in my draft, that we include a definition of what educational program or activity means. It's very specific. And, you know, it's in any location, event, or circumstance over which the school exercises substantial control over the respondent and the context in which the sexual harassment occurred. So when we're tying Title IX to educational programs or activities, I think it's important people know what those are. So I've suggested that as an additional definition. You'll see a formal complaint and what it's comprised of. I included recipient because the school and/or the school district is the recipient of any kind of formal complaint. And so I thought it was important to identify all the parties. And then I included retaliation up front because a large part of this Title IX policy, and what I think should be a large part of Concord School District's policy, is if there's retaliation separate and distinct from a violation of the policy, we will handle that. So that is included. Okay, so then what goes on are the normal definitions under that you would expect in a Title IX policy on sexual harassment, and that is a definition of sexual harassment. The one difference that I'll bring out between these new regulations and the old one is that the definition is much tighter. Okay, this whole policy, and I'm just going to say this, is less survivor/victim friendly than the last one. Okay, for example, it used to say that there's 3 kinds of potential examples of sexual harassment, and they're included in the definition section. But the second one is the one that says unwelcome sex-based conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive. It used to be, it could be just severe or pervasive or objectively offensive. Now it has to be all 3. Okay, so again, that's pointed out in the definition. And what I did was, in compliance with our 30301 guidance that says you must include definitions and you must include examples. I went ahead after the first two specifically and included examples of a quid pro quo type harassment. Okay, and I included definitions of unwelcome sex-based conduct, where we're talking about the, severe, pervasive, and objectively offensive. I think it's important to keep those examples near to the behavior described. But again, I'll leave that to you because we will go on and you'll see some other examples. The thing I'm also going to ask for guidance on this particular is number 3. Sexual assault, dating violence, domestic violence, or stalking is one of the areas of sexual assault. When you look at the state law, it's very confusing. And so I have definitions. I looked at them. They'd be about, to put them all in there, would be about 3/4 of a page. But we added language that just said consistent with state law and did not define those specific behaviors. If you all as a board think it's important and you really want to have this be very complete, I will certainly include definitions of those in there if you would like them. Okay, and then as you see, additional behaviors that could constitute sexual harassment are listed. Moving on. Okay. Again, go ahead.
So let me stop you there again, and I'm going to keep recapitulating and circling back just because it's an unusual situation. I think it's different from the way the committee usually operates because we don't, number one, we're considering adopting this policy because it's required by federal law, not because we are choosing to, make some of these changes, but we have to do that. And then secondly, because there's a very tight time frame, this law takes effect on August 14th. What you have been trying to do is to work with the School Boards Association. They're coming up with a model policy. At the same time, you're trying to make sure that we are making this as strong as we can and as strong as we did when we reviewed the policy last year. And that is challenging because we're trying to align the legal requirements under New Hampshire law, the kind of thoughtful policy work that we already engaged in, the thoughts that you yourself have coming in and looking at what we should be doing. And we're trying to align all of that with this new federal rule, which is less protective of victims. And so it's challenging. And I think, let me say again to those who are watching, here's what I am thinking from a procedural perspective. If we want to make sure that we have the policy in place in time to comply with the federal law when it takes effect August 14th, my hope is that the language of whatever version of the model policy or whatever version you have, Karen, can be included in our board book. And, if it's not the final, it's not the final, but we've got to have something that we put out there so that everyone can see it. That will be for the first reading. So it won't be voted on by the board at the August 3rd meeting. But we'll go through that first reading process. And then in the event that there's not a stay issued by a federal court or something else that would relieve us of the burden of having to comply with this federal requirement by August 14th, we would then schedule a vote of the board at a separate meeting that would just pertain to this policy. So for everyone who is listening, we don't intend to have a detailed discussion of this on Monday. We've got plenty on our plate with school reopening. That's not going to be the focus of that meeting. So, but we do want to put this out there because we have to be in a position to comply with the federal law. So again, it's kind of an unusual situation, but should we be adopting the policy, we'll schedule a special board meeting to consider it, and that will probably be, August 10th or something, so that we can have it in place for August 14th. So even though it's not, and we're not following along necessarily with the pieces that you're speaking from, you're just giving us an overview of kind of the issues that you see, but we will be making a draft public. It's just we don't have that draft yet, and we will not be adopting it without taking public comment, but that won't be on August 3rd. It'll be at a future meeting.
Perfect.
So it's very
Jenny,
unusual. So, yeah.
Yeah,
Kathleen, yeah.
Yeah, I had a question. Wow. So let me, I guess it's directed for Karen. And also Jenny. So the board will have an opportunity to amend this as they see fit, because there may be areas, and I think of number 2, that's what caught my attention, that you may want to take each one of those areas, severe, pervasive, and objectively offensive, and make them single items. So, so we're going to put this together now as one, but after we get this on, set up for Monday, but later on, we can make those changes so that you can strengthen it in that way. That's what I'm thinking about down the road. Okay.
I think this is what, Karen spoke to, that, our hope had been that Secretary DeVos would give districts a little more time. It's really so challenging to be trying to comply with this new and very different federal law while also trying to deal with reopening the schools. But in the event we have to, we will pass kind of the bare bones model policy to make sure we have it, in place, but then we'll absolutely have further conversations about how do we make this reflect what we have chosen to adopt as a community and as a district, and do everything that we can to be consistent with all of the work that we did last year and that we have been planning to continue with anyway. And
that may be an area number 2 that you want to address down the road. Okay. Yeah, that was my point.
Yeah.
Yeah. And I sincerely hope that by Friday we will have the final model policy from the state, and I will work with Lyndon to get my recommended changes in there, so they'll be of a different color and you can like them or not like them. And then the other thing I wanted to point out is that within the adoption notes, there is language in there that says we are, as a district, able to create additional or more specific procedures, but that any such additions, they just have to apply equally to both the respondent and the complainant. Right. So, my goal all along, and call me crazy, is that, we can adopt a model policy and just be like every other district and have all the same language, or we can really put the time and effort in, and I know you all are. I'm not singing to the choir. I think we want the blue ribbon standard, and I think we can make that happen. So I really appreciate that comment, Kathleen, and the ability to really look at this and make it our policy.
Right.
So,
right.
Okay,
That's
so,
important.
Yeah. Okay, moving on, I just want to point out, again, the definitions are there, or, excuse me, there's some examples of, more examples of sexual harassment. And then there's language in there that says, Title IX with regard to this policy does not apply outside the United States. And if the school system did not have that substantial control over the program or activity, it's not applicable. And we're pretty clear in that, in that guidance. Let's see. I'm not gonna, I know y'all can read this and I don't want to beat a dead horse. One of the things that is now required, again, this is a little more survivor victim friendly, is that when a student makes a report, whether or not they decide to go forward with a formal complaint or not, we as a district have to discuss and possibly provide what are called supportive measures. They're free, they're non-disciplinary, non-punitive, and they're individualized services that have to be offered to the complainant, and in some cases to the respondent. And I gave you some of those in the policy 1 through 4, and then I've recommended a couple extra ones that will be included in our iteration of it. Again, these are really, really important, and whether or not that complainant decides to go informal or says, no, I don't want to pursue, I don't want to go that way, I'd rather handle this through conduct, the regular conduct system, we still have to have those supportive measures. That's my responsibility, to have that discussion, to work with the educators on potentially what supportive measures would be helpful, and then to make sure we document exactly what was offered and exactly what we're putting into place. Heavily focused on, you're going to see that language throughout the policy as far as supportive measures. Okay, it then goes on and talks about your Title IX coordinator, that's me. And it goes through the duties and what are the responsibilities and the things that I'm supposed to do when a report and a complaint come in. I looked at these, I rearranged them chronologically in my draft because they kind of went all over the place, and I thought, well, let's just keep it as it's going to happen. So those are included. There's 10 of them. If I become unavailable or unavailable due to a conflict of interest or some other disqualifying reason, then unfortunately, Kathleen, it'll be up to you to find another individual with the appropriate training qualifications who can step in for me.
Right.
So training, there's a paragraph in here that says, thou shalt train. You have to train, you know, we have to train on to the employees and to the students, but everybody involved in the process, your Title IX coordinator, your investigators, your decision makers, and any people involved in the informal resolution process, we have to ensure that they are properly trained. Okay, and that I can do a lot of that. Okay, so that'll be good, or we can use you know, other means to have that happen, but that'll be very important. And okay, confidentiality is the next area we're touching upon. Tom, I think you asked about this a little bit. We will do our best to protect the confidentiality of a complainant and of a respondent, quite frankly, and it'll be on a need-to-know basis. There will be certain people, obviously, who need to know, but we will keep that to the lowest possible number of people. And also, you know, along with that is we have to be honest and manage, I have to be honest and manage the expectations of the complainant to say, we still have obligations to report even outside of school, for example, neglect and abuse, DCYF, law enforcement agencies, could be the Department of Education on code of conduct if it's an educator or misconduct issue. So, but we will, as I said, to the best extent possible, try and keep the notification to a who needs to know basis. Make sure that can't retaliate for someone who files a report or a complaint or cooperates in the investigation.
Karen,
And
hold on, Karen.
I'm not sure what happened. We weren't able to hear you clearly the past couple of, I don't know, 20 seconds.
Okay. Retaliation?
Yes.
There's a paragraph dealing with retaliation and the fact that, you know, it applies to both. You can't retaliate against the complainant, the respondent, any of the witnesses. The only time that it is not retaliation is if somebody comes in and makes a false complaint or lies in some other area. We are allowed to take action against that person, not for reporting, but for the fraudulent or fake reporting. Okay. There's a provision in here about a conflict of interest, and it basically says that if the Title IX coordinator, investigator, decision makers, or informal resolution person can't have a conflict or a bias either for or against the complainant or the respondent. And then it talks about dissemination and notice. And this is what I referred to earlier, is that once we get our policy in effect, we absolutely have to include it in our student and employee handbooks, on our district's website. We should include it when I got some notice when I came on board, you know, in my, what do you call it, my employment paperwork. And then we got to figure out the best way to get this information to the parents or legal guardians, employees, and collective bargaining units. So a big emphasis on making sure not only do you have your Title IX coordinator in your policy, but make sure everybody else knows about it. Okay. Records and record keeping, just briefly on this, huge emphasis now on maintaining records of investigations for a period of at least 7 years. Also, any written materials that are used to train on Title IX and its policy must be maintained on the website, or copies be made available to the public if requested. Okay. All right, then we get into the nitty gritty, and that's the reports of sexual harassment and formal complaints and the district responses. So this just gets into, in the reporting phase, it says that basically anybody can report sexual harassment anytime. And to whom, Tom, this is coming back to your question, they can be made anytime to any person by, and I'll get back, in person, excuse me, by mail, by telephone, electronic mail, so verbally or in a written report. It can also be anonymous, but I'm putting in language that discourages that only because we don't have a lot to go forward on, but it can still happen. Now, reporting can go, it can happen, somebody can walk into my office and make a report, or this is what we really need to train our employees on, is that there's real specific guidance for K through 12 in the Title IX policy that says any employee of in a school, okay, for K through 12, if they learn of a report, if they hear of something, that the school district then has actual notice. And that's pretty scary. So a good example of that is Jen's sitting at home and she has a son who has a friend over who's in the school district who mentions, hey, I heard that Allison was sexually assaulted. Okay, Jen hears it. Potentially she has actual knowledge and she now needs to report that because that triggers our response obligations. So that's one of those really important training tips. So that's what happens with reporting. And again, this reporting, I just want to emphasize, is in addition to the mandatory reports that we always talk about, to DCYF or abuse and neglect, to other law enforcement agencies, or maybe even to the New Hampshire Department of Education. Okay, and so once a report is made, we have to respond. So what happens is that I, as your Title IX coordinator, when I hear of a report, it doesn't matter how it comes to me. Okay, it can come in any of those ways that are already talked about. That means I have to jump into action. And what happens is I either reach out or I speak with, if let's say the complainant comes to me, but if she doesn't or he doesn't, I have an affirmative obligation to reach out to that student or employee, bring them in and have a conversation with them and talk about supportive measures, talking about how to file a formal complaint, and talking about both formal and informal grievance procedures. That is something, it's mandatory, okay? As I said earlier, this new policy is very due process heavy. And so what it says in our policy and what we must remember is that even if we have other avenues by which we want to handle the behavior, let's say it doesn't result in
You broke up a little bit. You said, in addition.
We can do that, but we have, sorry.
Yeah, I think it was an upload speed issue, perhaps. Maybe if you could just repeat the last couple of sentences, that would be great.
Sure. You can't take any disciplinary action against a respondent until the process is complete, no matter what so if you're doing a Title IX and yet you could potentially issue sanctions under a different process, like student code of conduct, you have to wait on any sanctions until completion of the investigation, okay? There's language in para 5 that talks about an emergency removal. That pertains to a student. If you have a student who we feel is a danger to the welfare or safety of employees or students, there can be a removal, okay? There has to be a risk and safety analysis done by myself and Kathleen to determine that we believe that exists. We issue the emergency removal, and then that student or employee has an opportunity to appeal that decision. For employees, though, it's not an emergency removal. That's the paid administrative leave provision that's currently in our sexual harassment instruction. And so again, even with that, we still have to say that we've done, and we will do a safety risk analysis so that that individual, if they feel they've been wrongly treated at that point, can file an appeal and ask for reconsideration. Okay. And then we move into the third section that talks about the actual grievance process, the actual filing of a formal complaint. A formal complaint can be filed by a complainant, a parent or guardian on behalf of a student, an employee or I, as your Title IX coordinator, can independently sign out a complaint if the complainant doesn't want to go forward and I, in consultation with Kathleen, feel that we have a larger risk to the school or the community and we need to further investigate. Examples of this, which I included, would be, let's say the victim says, I don't want to go forward, but I've heard this name before potentially of the respondent and I'm seeing a pattern. Okay, that would be one where we may say, we're going forward anyway. If there's a serious sexual assault or a weapon being used, there are certain factors that are going to trigger. And again, I'd go to Kathleen and say, I think based on the bigger picture here, even though the complainant does not want to be the one to sign out the complaint, we have a duty and obligation to still investigate and file a complaint. Okay. If we do that, go ahead.
Can I jump in for a question
Please.
around reporting? And it's kind of tied to that also. Are there
Sure.
provisions in here for folks that may not be able to do a written complaint? Are they able to give a verbal complaint and then have someone write it down for them?
Yes.
Is
Yes.
that written in there? So, because
It is.
sometimes we may have somebody that maybe has a disability and may have a difficult time with writing, and even it could be verbal too, right? But
Sure.
but there are provisions so that they can still, okay. Just check.
Absolutely. So
Great.
the complaint can come in any way they can get it to me. So,
Okay.
and if they walk in and they say, I'm not sure I can hear you, or I need an interpreter, or I need help writing it, we'll help them. So absolutely.
But is that in there? I guess that's
Yeah.
is that in the policy so that
Yes,
we have
it
that
is.
provision written? Okay, that's.
Yeah,
that's great.
specifically,
I didn't
it's in
see that.
it's in the timeline, because if there's a delay due to the need for an interpreter or something, it's all in there.
Okay, I'll look at that. I didn't see it, so thank you.
Yep,
Great.
no problem.
And Tom Furto also has a question. So Tom, go ahead, please.
So Karen, I just want to be sure that I'm crystal clear about this. And I think that you have the answer. I'm just not sure I've heard it yet. So let's say that in your example, a complaint doesn't reach you. It goes to someone in the building. So student A makes a complaint to a teacher. Teacher brings that to the principal. Principal says, you know what? This just isn't a big deal, and it stops. I mean, we as a district, you as an individual, Kathleen as a superintendent, we can't control that kind of behavior. What if we got in place that we can really make sure that that a complaint goes to at least maybe one or two or three people who can provide checks and balances to one another, I guess.
Excellent point. There's legal liability for failing to report, and it's stated in the policy. If an employee receives notice of a report and they fail to report it, then action can be taken against them. So
then I think that's perfect. I think that if we're able to make that well known to folks during the trainings,
yeah.
Then that will certainly ease my mind and perhaps others. Thank you.
And Karen, they have to understand that they don't need evidence. They don't need to have information that's solid. It can be a suspicion. It can be something they overheard. So that's going to be critical in the training, that you don't need to prove it before you bring it forward.
Yep, excellent point. And I've been hammering that already to say, you know, don't wait for a black and white. As soon as you suspect it, you see something, say something.
Say something, right.
Yep. Okay, and again, I know I'm
Karen, we've got one other question, and I just want to say thank you so much for taking the time to go through this, because I mean, in hearing about the new Title IX rules, I've thought of this as, oh, this is a negative thing, and that you know, the timing is very tough. But what I'm hearing from you is this is kind of pushing us in a way that we want to be pushed to have the specificity on some of these things that we are very much wanting to have in place, and so that is really important. So thank you for going through. Chuck Crush has now joined us. Thank you. I'm glad you were able to make the meeting, Chuck. And
yeah, thank you.
Go ahead.
Yeah,
okay.
yeah. Just a question. Hi, Karen.
Hi, Chuck.
Hi. Nice to meet you virtually.
You too.
Quick question. So in the scenario you gave where you feel that a complaint needs to go forward, you and Kathleen discuss it. Say the complainant does not want it to go forward. Would you protect the anonymity of that individual who does not want to go forward with it? Can you talk a little bit about that?
Sure, to the maximum extent possible, and that comes into the management of expectations. The complainant may not want to go forward, but if we feel there's a bigger risk and we have a reporting obligation outside of school to, say, a law enforcement or DCYF, then I'm going to sit down and I'm going to say, you may not like my answer, but I'm going to be honest with you. You don't have to go forward, but we do. So yes.
Okay. All right. Thank you.
Yep.
You know,
Okay, so
I see it, Chuck, like a guidance counselor's responsibility. You know, they can keep information confidential, but the minute that it impacts their own self, in other words, their own harm, getting harmed in some way,
Sure.
They have to reveal that. So I see it the same way. I mean, if somebody comes forward, is reticent about, speaking out, and yet could really bring harm to them or has brought harm to them, then that to me is the difference.
Agreed. Thank you. Thanks for the clarification.
okay. So we're at the point now where somebody heard about a report. They came and saw me. I reached out to the student, for example, and said, come see me. Let's have a conversation. And we talk about it. What I'm going to do is, again, I'm going to walk that complainant through potential supportive measures if something is going on. And then if that complainant, a boy, a girl, an employee, it doesn't matter, says, I want to file a formal complaint, then I will take that complaint, and it has to include certain elements which will be on our form. It has to be signed by the complainant. It can be an electronic signature, it can be an X, doesn't matter. And it has to request an investigation by the district. So again, that's a tightening of the rules. And I got to be honest, guys, I don't think we're going to get many of these because I think people are going to be so overburdened with it, but we can still use the processes that are coming out of this. So that's the good note. So we get the formal complaint. The first thing that I need to do is provide notice to both the complainant and the respondent in writing, plus their parent or their guardian, that there has been a complaint. And I can only provide enough information, FERPA pops in here. We have to be careful under FERPA. But the reality is the complainant is going to know who the respondent is. But from the school district's point of view, we're going to reach out. We're going to notify the parent or guardian. When I say we, that's probably the principal or the superintendent, or I'm happy to do it, but I think that's going to be, that's something we'll talk about.
What if the student is 18?
Well, then we have to look at that and we'll have that conversation, and under FERPA, we may not have to. Okay. So I'm also going to talk to them about, again, the formal process and any informal processes that are available, and we'll get to those in a little while. Okay. Under the new rules, there has to be sufficient detail in the complaint to identify the people involved, the conduct allegedly constituting sexual harassment, the date, and the location of the incident. So that'll all be pulled out as part of the formal complaint. And what I'm going to say in my training, and have said all along, is when somebody comes in and makes a report, we don't want staff, employees, teachers, other kids conducting an interview. That's not what we want. We just want them to say, wow, this sounds like sexual harassment, and make the report, and then we'll start the process from there. Okay. We have to let the respondent know in the notice that they're presumed not responsible up front, okay, for the alleged conduct, and that determination of responsibility will only be made at the conclusion of the grievance process. Again, heavy due process rights, but it has to be in writing. Each party, the respondent and the complainant, are entitled to have advisors of their choice who can be attorneys present for any meeting, any investigational interviews, any. For employees, they are also entitled not only to an advisor, but to a union rep if they so choose and are part of a collective bargaining agreement. Okay. Each party is entitled to review and inspect the evidence. And then, let's see, I said support measures. And again, it may be that the respondent needs, the perfect example I can give you is that it may be that we just we don't just think about the complainant at this point, because remember, the respondent has due process rights too, and nothing's been proven. So maybe there's a mutual no contact order issued, or there's a modification of his or her schedule as well, the alleged respondent. So those are kinds of things we need to really be looking into. Now, all right, so I go ahead and I take the complaint. The next thing that happens is I'm going to have a discussion with Kathleen to determine who our investigator should be. A formal complaint's been issued, and we're going to look at this and we're going to say, okay, where is this? Hopefully it's going to be within, let's say, best example is we have a high school student who's sexually bullying another student. Probably what's going to happen is one of the assistant principal who's named as a potential investigator in our sexual harassment complaint will be the investigator who will be trained and who I can work with. Okay, I've already done some training with all 10 of them or some of them. And then the principal becomes the decision maker once the investigation is complete, and more on that in a minute. And then in that scenario, Kathleen, you would be the appeal authority. Okay. Right. There may be instances where we have to hike it up a level, where we say, nope, we're going to have a third-party investigator come in, like in the Howie Lowen case. If that happens, third party comes in, does the investigation, we'll appoint a decision maker. We'll talk about who we think that should be. And if you can't be the appeal authority, Kathleen, for any reason, then it goes to the school board.
Right.
And okay. All right.
Excuse me 1 sec. Gina does have her hand up. So Gina, did you have a question?
I do. Can we go back to who is a non-eligible student under FERPA?
Hang on, we're non-eligible student under FERPA.
Okay, initial steps and notice of formal complaint.
Yeah. So FERPA applies, and correct me if I'm wrong, Kathleen, I know you probably know this, to students under the age of 18, I believe.
That's right.
So non-FERPA eligible would be anybody over the age of 18.
Okay, but then why, if they're over the age of 18, would we be contacting the parent or guardian?
Okay, a child parent guardian, if the complainant is non-eligible student under FERPA and the respondent non-eligible. Good point. I'll study that a little bit more. It could be that they're an eligible, not a non-eligible, but I will work on that one.
Okay, I'm confused. I was confused.
No, I don't blame you. Believe me, my head's been spinning for weeks now.
I totally believe. I believe.
I think we have to consider this because we have students at the high school that are 18, and we have kids that are all the way up to 21. So we need to be careful about this. And a youngster with disabilities, how does that work when they're over 18 and still living with their parents? So that's a question we'll have to grapple with a little bit.
Right. Okay. And I think that's. Go ahead.
I think Chuck also had a question. So I was.
And that was my point about the kids from 18 to 21 who are served with disabilities. And Kathleen raised it up. How does that work? Because you would need to contact their parent or guardian in that case. I would think. I mean, I would hope.
I would say so.
Yeah, me too. Thank you.
I know that if the parent is not the guardian, and the student is still, like, let's say the student has a disability and has a right to education up to the age of 21, but the parent has not been determined to be the legal guardian, that's a whole other ball of wax.
Yeah. Yeah, no, but those are the specifics to Concord that I think are going to be so awesome and set our policy apart. It may not be that we want to put it all in the policy, but we at least have to have thought it out so we have a process in effect. But I'm all for one of keeping it complete and putting everybody on notice. So, all right, if we have, and I'm jumping down under the general provisions relative to the Title IX grievance process, because we've already talked about copies and notices and risk analysis and emergency removal and administrative leave. If there are additional allegations that come forth after the initial complaint, we have to renotice. We just have to put both parties back on notice and their advisors that there have been additional allegations that may affect the time frame, but as long as we document any delays, which I will be all over, we should be okay there. The no interference with legal privileges, that means obviously it could be a doctor, it could be a psychiatrist. We cannot be trying to ask questions that are legally protected under privilege. And that's part of the training for the investigators when I do their training, but it needs to be put in our policy. And then if there are multiple complainants, formal complaints, if you will, under the same facts and circumstances, we can consolidate complaints. If we get to that point, I'm probably going to advise that we have more than one investigator, because people are going to, the thing about Title IX and the Title IX coordinator is that I am there to serve both parties. So we just want to make sure if we get multiple complainants that we serve them adequately as well. Okay. Remedies, under number 7, it just talks about the fact that we have to put the consequences of what can happen to a student or an employee in our policy, and we have. And disciplinary, remedial actions, what those can be. In addition to, you can do disciplinary sanctions, but you also might have some remedial actions, scheduling adjustments, removal from an extracurricular activity, for example. I looked at one of the things that concerned me was the inability to register for a class. And I was concerned about that. I thought, wow, that feels like we're depriving them of an educational opportunity. But you don't put remedial actions into effect until after there's been a determination of responsibility. So we're okay there. Okay. For purposes of the investigation and how long it can take, and I have a whole timeline for you, we are counting calendar days, unfortunately, but we have to, because otherwise, if we take too long on our investigations, that can fall under a definition of deliberate indifference, which means we didn't act quick enough once we knew what the facts were. So, and if we have any delays and extensions of time, which I guarantee are going to happen, witness might become unavailable, we may be just starting summer break or Christmas break. The important thing is, 1, to document what it is, and 2, to make sure that I am keeping the parties informed of the reason for the delay. Okay. Investigations. I'm supposed to be the one coordinating the investigation. There may be times when Kathleen says, nope, I want you to do it. I can do it. The problem there, and that'll be a discussion for Kathleen and I, is that if I am an investigator, I am then pulled back from being able to advise or be a part of any other part of that investigation. So we'll look at that, and I can clearly see instances where, Kathleen, you may say, nope, I want you to do the investigation. And I got that, so we'll decide. Okay. We have to, both of the parties are allowed to see the investigation, believe it or not, now before it is completed. In other words, an investigator doesn't have to make a finding of whether or not the allegations are substantiated, but what they do have to do is they have to make sure that the evidence that is present, and it can be videos, it can be exculpatory or inculpatory evidence, any kind of stuff that's being considered, has to be provided to the parties. We have to tell them that the burden of proof is a preponderance of the evidence. That's been the recommendation from the district, is that we stick to, more likely than not, as you all probably know, 51% chance this actually occurred. We have the option of going with clear and convincing, but the recommendation is that we not hike that standard up to the next highest level. That's a point of discussion if you all feel that you want to for any reason, but if we do it for student complaints, we also have to do it for employee complaints. My recommendation is we leave it at a preponderance. Now, in the comment about confidentiality and who needs to know, we are not allowed to advise. I used to give a warning in investigations to both the respondent and the complainant and ask them not to discuss their testimony with anybody except their attorneys or their parents. We're not allowed to limit them anymore. There's guidance in there that says you can't restrict the ability of either party to discuss the allegations and present relevant evidence. Okay, again, you have to advise anybody who's participating in an event, provide to a party, so the complainant or the respondent, written notice of the time, the date, the location, the participants, the purpose of the hearing, investigative interviews or other meetings, and you have to do that with sufficient time for them to be able to prepare, okay? I have to provide status reports as we go along, and we've provided guidance in there that says at least every other week, so that people, you know, it's transparent and both parties know what is going on. So before the completion of the investigation, okay, the investigator through me is supposed to send to each party and the party's advisor any of the evidence subject to inspection and review. They can have it in electronic format or hard copy, and they get 10 days to review it and submit any written responses, which the investigator then has to consider before they wrap up their investigation. Okay, so there's your 10 days. Then after they get the written responses and the investigator has answered all the questions, then the investigator, as I said, provides the investigative report summarizing all the evidence, witness credibility, so on and so forth. And that is provided to the parties, their advisors, and it says it has to be done simultaneously, either in electronic format or by hand. Okay. And then each party is then given an additional 10 days upon completion of the formal final investigation to review it and to provide a written response. So you can see where these timelines are going to come in, and we're going to be like, holy moly. So the investigation becomes complete, investigator's done. The next person that comes into the process that we'll need to train is the initial decision maker. So if the assistant principal did the investigation, let's say Mike Reardon at the high school is the decision maker, he will go ahead and he'll take a look at the investigation, and he will give each party 10 days to submit any questions that they want asked of the other party, okay? And he gets to determine whether or not those are relevant. So again, we're beating down the clock, and I have to keep careful track of where we are in the time frame. All right. And then again, the initial decision maker, go
I
ahead.
think Gina had her hand up again, so before we get too far, Gina, do you have a question?
Yeah, I'm sorry. I'm just trying to keep the timeline in the margin. So
Yep.
a complaint would be filed. There's 80 days to do an investigation. Then there's 10 days to inspect by both parties. Then the investigator must prepare a written report. How long do they have to do that?
Well, that is, I'm sorry, Gina, if you look at the very last page, where did you get 80 days?
I'm looking at, okay, so I know that not everyone has these documents, but I'm looking at the document that had the redacted, like, what's the word I'm looking for? Had the indifferently deliberate crossed out. So is that the document that we're working from? So
sorry, but
I'm looking on page 15.
Okay.
The very first under D, time frame of grievance process.
Mm-hmm.
This is through the initial determination of responsibility within 80 days after filing the formal complaint.
Yeah, if you go, okay, 20, 30, 40, 50, 60, 70, 80, 90, it's going to be a little longer. If you go to the very back page, we have spelled out all of the exact frames. So my apologies there.
So I'll go back, sit down and be quiet because you've already done it. Never mind.
No, because I want to be consistent. And again, there's going to be more review of this, but it is not an abbreviated process with all the due process rights that are being afforded both parties. Okay. So ultimately, the initial decision maker, under our scenario, the principal will issue a written determination, okay, and will say, here I either find you responsible or I don't. He has to include findings of fact that support any determination, and if there's any applicability to the district's code of conduct to the facts. Okay, we can comment on those as well. The rationale for his findings. And then he issues the written determination to me, the superintendent, and the party simultaneously. Okay. Now, there are reasons for a dismissal of a formal complaint once filed, and there's mandatory where it wouldn't, the allegations or the conduct wouldn't constitute sexual harassment even if it were proved, because it doesn't fall into the, the elements we need to prove. If it didn't occur in our education program or activity, or it didn't occur against a person in the United States, we can dismiss those out of hand and say, I'm sorry, they don't comply, they don't come in under Title IX, but we could still use other school policies or regulations to handle the complaint if we wanted to. Okay, there's no double jeopardy in administrative forum, so we're okay there. And then we have a,
Gina
go
has
ahead.
another question. Sorry. Go
Sorry.
ahead, Gina.
No,
So if there's a school-sponsored trip to Canada, to Montreal, and
outside the United States.
okay, no, I get that, but I'm inclined to say if it's a school-sponsored trip, we should have the same policy, same behavior required of students on a school-sponsored trip, whether you go to Pittsburgh or whether you go to Montreal.
Right.
So
And Gina, my response would be, we may not be able to handle it under Title IX, but we have some other policies where we could probably handle it. But jurisdictionally, especially for college and universities, this is geared towards a semester abroad, and they're saying we're not handling those.
So I think the point would be we would not be tied to all of the due process requirements, but if we have a policy that's in effect that, for instance, governs student conduct, it would still apply to student conduct on the Montreal trip. It's just that Title IX wouldn't apply, right?
Correct.
Okay,
Yeah,
I just want to make sure that no one gets a free pass because they've crossed a border.
Well, actually, I can think of a way out of all of this, and I'll share that at the end as a prior defense attorney, but I'll save that. Okay, and then you can do there's other reasons you could dismiss a formal complaint. Let's say the complainant comes into me and says, I don't want to continue any longer, I want to dismiss it. We can dismiss it. Again, we're going to document why. If the respondent, and this is what I was just about to say, if the respondent is no longer enrolled or employed by the recipient. So let's say the respondent gets a notice of allegations. If I'm his defense counsel and I think there's something going on here, and again, this isn't criminal, but I think there could be some sanctions that could be pretty serious. We may leave the district. So if they do, then our complaint goes away. Unless, well, no, our complaint goes away. Okay, if that happens, then I immediately have to send written notice of the dismissal and the reasons therefore to all parties, okay? And then finally for tonight, we have our appeal process. So not only do you get to go through and get all the due process and the timeframes and the ability to review the evidence and then the ability to review the final report and then, all the other things that go on, which, again, are great. There is an appeal process, and again, there's a time frame involved. And what can happen is, once a determination of responsibility has been made, then a written appeal has to be filed within 10 days to the superintendent or whoever the appeal authority is. Again, we're thinking in terms of principal does the decision making. It comes up to the superintendent, who will then review it. There are specific reasons for an appeal: procedural irregularity, new evidence, bias, or a conflict of interest on behalf of any of the major players like your investigator, your Title IX coordinator, a decision maker. Okay, and then there is language in there that says, or if you want to, Kathleen, you could say, well, what's your reason? And even though it's not a stated reason, if you think it's a valid reason, you have that discretion to go ahead and grant the appeal, but you have to obviously provide that opportunity to both parties. Okay. All right. And then again, okay, so you had your initial decision maker on the responsibility piece. Believe it or not, there's a second decision maker on the appeal process. Okay, and there's some timeframes that are discussed in the final in the back there that are laid out for you. And so each party would have the opportunity to appeal a finding of the decision maker. Let's see, all of this is easy to read, so And then the finality of the determination of responsibility, once you get through the formal appeal process, the determination becomes final, okay? And if they come in after the 10 days and there's not a good reason, then it can be considered untimely or not within the reasons for appeal. And then we can go ahead, once it is final, we can implement any remedies or disciplinary sanctions. And then we have the obligation, let's say something is found to, the respondent is found to be responsible, then we have to make sure that we continue to provide supportive measures to the complainant. The other thing that can happen instead of a formal complaint process, with the swearing of the complaint and then all the investigations, is you can do an informal resolution. Now, what's interesting about informal resolution is the complainant still has to sign the complaint, okay, and say that they want it to be investigated. It doesn't have to be the extensive investigation that we would do. We just look into it in a more topical. And what can happen is the parties can agree up front to how it's going to be handled. We might have somebody come in and do remediation or arbitration. We don't want to go through the whole thing. The parties have to consent in writing ahead of time. The possible sanctions have to be made known to both parties. And the one instance where we cannot do an informal resolution is like the Howie Long situation. If we have an allegation of an employee having sexually assaulted a student, you can't do informal resolution. We take that out of their hands. We just also need to make sure, if we go through an informal resolution process, that we make sure that we inform both parties of all the potential outcomes, and that can be, the records, the maintenance of the records, and the ability potentially for that record, to be in existence for the respondent if ultimately there is responsibility found. And let's see, the last thing I want to say about the informal complaint process is that time the informal resolution process is going on, resolution, not complaint, a party up until the decision on accountability, responsibility, either party can say, I'm pulling out, I don't want to do informal anymore, okay? What happens though is if we get to the resolution piece and there's a determination made on informal, the complainant then can't come back and say, I'm not really satisfied with the outcome, I'm going to file a formal complaint again. They're barred by that, and they're put on notice of that up front. And then finally, you've got your summary of your grievance process timeline there. Gina, I'm sorry, I will make sure it all blends earlier in the policy, but that's how it's laid out. And then I put down here a note that said add a bypass provision, and I just didn't get to it today. And what that means is if a student doesn't want to come into our school or meet with me or anything else, and they want to go directly to the Office of Civil Rights or the New Hampshire, Commission, I've got the points of contact. That's called a bypass provision, and we need to include that in our policy, which informs them, gives them the contact information, and tells them they can go directly. And that's already in our other sexual harassment policy. So, in a nutshell, everybody, that's an hour or more.
So thank you so much. And I'm sorry that this is your introduction to the committee and our process, because it's such an unusual situation, but you did a great job of going through the key elements. And I think, again, I'm repeating myself a lot, but we've had different members join at different times, so I'll be brief. I think my thought on how to proceed, and we can have a discussion of this as a committee if we need to, would be that we would consider moving forward to the full board for first reading, whatever is the best draft that's available based on the work that Karen has done as of Friday when we post the board book. So basically what we want to do is get a draft of this forward to the public, to the full board, even without having gone through it in the way that we typically would as a committee. And that's because of the fact that it takes legal effect. The federal rule takes legal effect on August 14th. Given everything on the agenda for our August 3rd meeting, it would not be our intent to vote on this at that meeting. It truly would be a first reading. And in the event, which I assume is what's going to be the case, that the rule is not stayed by a court or amended by the federal DOE, what I would propose is that we would schedule a full board meeting on August 10th, with the only agenda item being consideration of the adoption of this policy, and take a vote on it at that time. And that way we can take public comment on it. We can pass it in as, you know, good a version as we can get to as of that date. But we won't get into a situation where we have to decide on this policy and hear testimony on this policy the same day that we decide on school opening. I just think that is going to be very difficult. So Kathleen has her hand up. So go ahead, Kathleen.
Just a quick question, Karen. When we talked about the appeal process, is the decision of the superintendent final?
Yes, yes.
So
it is, unless you're not the right, unless you are disqualified for some reason, and let's say you've acted on it as the initial decision maker, then the appeal would have to go to the board. But once they make a finding, yes, it's final.
Okay, thank you.
Yep. Gina, I'm sorry. You look like you're administrative due processed out.
No, just a headache. Not enough water.
Okay.
So
The other thing, Jenny, I wanted to let you know is I think when they release the policy on Friday, assuming we don't get another iteration, I think the guidance, and you'll know this better than I, is that if you wanted to, you could waive the first and second readings and go ahead and adopt it. I think that's what they're going to say to make the timeline, but whatever you think is appropriate.
And we have done that before. When I was looking back at what we did last year with our policy work, we did at our August meeting, we wanted to get policies that had been worked on over the summer in place, and we did waive the first and second reading. But I think what I'm proposing is I just don't want to make it unworkable for the August 3rd meeting. So I think we could have a very abbreviated first and second reading, and it would be unusual because we as a policy committee won't, we haven't seen the details of it. We haven't looked at the language of it. But I think that's the best way to proceed under the circumstances. Gina, go ahead.
I'm comfortable with that as long as we set a definitive date by which we can have sort of significant additional public input and time to sit with this and make it Concord's. I mean, I understand the urgency to get it done before the deadline, but I think if we're going to approve it or, vote on it on the 10th, I'd like to put in everybody's mind that at that meeting on the 10th, we say, okay, we're going to look at this, we're going to review it, we're going to modify it, we're going to do whatever we have to do to make it Concord's and get significant community input, and then finalize whatever we're doing by X date. I don't want this to become one of those, oh yeah, we have to come back around to it.
Yes, and I so agree with that. And I knew you would say that because you always do. And I appreciated that you do, Gina, because I actually took the time this afternoon to read through all of the minutes of the communication committee meetings and the board meetings over the past year, because I wanted to get a sense of what was the unfinished work, because I know, we went through this process last summer. We had such great community input on many of these policies that will be affected, that we will seek to make consistent with this new policy. And I want to make sure that we do that too. And so one of the things that we talked about on Monday when we had our scheduling meeting and we looked at the upcoming months of meetings is that we have scheduled a Communications and Policy Committee meeting for September. And so we want to get through the whole school opening thing, and then we've got to dive back in. And I know, looking at the minutes from last December's meeting, and I think also from last February's meeting of the Policy Committee, we had a specific schedule on it that you had put together, and we had specific plans of what policies we were going to look at when, and we absolutely have to do that in September. And that will include all of the other kind of continuation of that work. And I'm not going to get into the details right now, but I did look through it. So I'll be able to, Gina, to work with you to make sure we've got a list for that September meeting of everything. And we'll work with Karen and we'll work with Kathleen to say, okay, well, what is our unfinished work from last year that we wanted to be doing? Then what are the new things that have come up? Some may be due to COVID, some may be due to new laws that passed, or just the typical policy work that we always do. And then some may be, you know, adapting, you know, giving Karen the time to have these Concord specific additions to the model policy, because you may not be able to do that by Friday. I mean, we may just have to take that, whatever the school board association model is, and we'll adopt it, and we're not going to be thrilled with that, but we will do that with the commitment that we will make it ours.
Yeah, and I was just gonna, that's a beautiful point. I was just gonna say, you know, this has a full force and effect of law. The rules do. So there's no creative writing on my behalf on those. So maybe you're right. Maybe we just say, up to you all, but maybe you adopt the model rules with the proviso that, and I'll continue to work with Lyndon and all of you, obviously, and Kathleen's idea about, you know, making sure we have those assets in place to help people who have those disabilities potentially, and we deal with those after the fact. I mean, where we would get in trouble as a district is if we did nothing by August 14th. I mean, the model policy, don't get me wrong, Will, and we all spent a lot of time on it, and I think it's good. I just think it's topical in some respects, even though it didn't feel like it tonight.
Right, and we want to go above and beyond. We really do. We do not want to lose all of that good work that we did. We do not want to lose your insight, because you were, you know, that's why we brought you on board, and we don't want to lose track of that. It's just, I mean, we're going to be completely underwater if we try to do all of this too fast while also figuring out school reopening. So I think that Gina's continued mantra, which I appreciate, of we've got to have a commitment, we've got to have a schedule. I agree really strongly with that. Kathleen, you have your hand up, and Gina.
No, I'm good. I meant to take it down.
Oh, okay. Did you mean to take yours down?
Is it down now?
Okay. And we have, Kate, I see that your hand is up. I mean, we don't have a public comment intention, but I also don't like not listening to people, so I will call on you. So go ahead.
Oh, I'm sorry. I thought there was public comment at policy committee meetings.
We had not intended on taking any at this meeting, just because it is so complicated. So there's certainly, I mean, and as you've heard, because thank you for bearing with all of this, you know, it's a really unusual situation in a lot of respects. So, I mean,
so it's
actually
more of a question than a comment, and it'll be very brief. First of all, I do want to acknowledge and thank all the work that was put into all of these policies by Karen Fisher Anderson, and I can't help but be struck and somewhat saddened how different things would have been if the district had a real Title IX coordinator and had a Title IX coordinator that other administrators and key people knew existed, and that they actually followed Title IX policy. So I'm so pleased that there is one in place now, but it's I think a overall comment that it's very sad we didn't have this in place previously. But my question is actually completely unrelated to the federal policy, and more just something in passing that Karen said as far as the training, that she has done some training. And I'm just hopeful she can comment on that more. What sectors or who, not specifically by name, but by kind of within the district has been trained? I think it was abundantly clear in the Perkins report that key individuals had no clue how to do a sexual misconduct investigation, and actually further hampered what happened. So I'm just curious who is trained, who is in the queue to be trained.
Sure. Great question. With regard to, I did an overview of Title IX to a lot of the principals, both the principals of the middle school, the high school, and all of the elementary schools I did on Monday of this week. So they've all been trained on an overview. Certainly not to the extent of what's in this policy, because quite frankly, they need to know where to find the policy, but they have an oversight of it. I then also did specific training on how to be an investigator to all of the individuals who are listed on our policy for sexual harassment investigators as part of, I believe it's 521. And so those people were provided, again, an overview of, and checklists and some things I've been working on how to conduct an investigation. And certainly got a whole lot more to do. I've also done some training on bullying, and I've done some training on boundary violations and grooming behaviors. And so I hope to reach out to, every time I get a request, I've met the request, and hope to get in the classroom as age appropriate and help with the students as well.
That's great. One more question is, especially related to the grooming. Will high school and middle school guidance counselors be trained as well?
Yes, absolutely. The training is going to be well advertised. I'd like parents to be trained as well, have forums. I'm willing to go anywhere anybody wants me to go to help do awareness and education. I think it's great for everybody.
Great. Thank you, Karen.
Sure.
Great, thank you so much. Gina, go ahead.
Sorry, one last thing. I'm a huge visual learner. And I'm wondering if it would help to, in addition to this policy, and I don't know whether it should be part of the policy officially approved or whether it's an addendum, but is it possible to put together a flow chart complete with like deadlines or number of days, so that like someone has a summary sheet of this comes in with X number of days, I have to do this, or so-and-so is doing this, or does that make any sense to you?
Absolutely, and some do exist from other institutions like a TICSA and OCR, Office of Civil Rights, put one out. What I would recommend on that one, Gina, is that we make it a training tool and something that
We lost her.
Yep.
to investigators, people who are involved in the process, and not necessarily put it in policy. That makes you. Did I fade out?
Yeah, we lost you.
So you were about to say your recommendation, and then you became very slow.
Okay. I think it's there are flow charts in existence from both the Office of Civil Rights and a couple of the big training organizations like a TICSA, who trains Title IX consultants. I think that's going to be a really handy tool for me to be able to hand out to the investigators and as I'm teaching. I'm just not sure I would put it in our policy per se.
Okay, I wanted to raise the idea and making it available to everybody so that expectations are clear and able to be. The policy is not always civilian friendly to non-lawyers.
Yeah, absolutely.
And so anything that makes it more user friendly to somebody who didn't mutate their brain at law school is, in my opinion, a good thing.
Yeah.
So.
Here's what I would propose. We should have a Title IX website for sure. And I think the policy should be on it at some point when I have a couple extra minutes, maybe do a video, not nearly as long as tonight, maybe 12, 15 minutes on the highlights if I can get it condensed. We have to put our training materials up there. I'd like to do a question and answers, kind of generic. And I think a flow chart would be an awesome asset to have on that website as well, and potentially in our handbooks. What do you think?
And thank you, Karen. The other thing I wanted to say.
Thank you.
Karen really wanted to have this meeting in person, and I know this is another instance where we're just so constrained by COVID, and it is a conversation that we're going to be having as a board of, when and how can we actually be meeting in person, because when I'm thinking back to last summer when we did all of this policy work. It was so beneficial. One of the decisions that we made as a committee was we weren't just going to like sit on one side of the room and have the public on the other side of the room. We had these sessions where we were actually sitting and talking with each other, and I thought it was really beneficial. And I think having to do all of this through remote technology, it's so much more stilted. It is really difficult. So I hope that we can get to the point where some of this robust policy conversation can take place in person. I'm not sure how, but that's just another piece of what we have to figure out in terms of the district's response to COVID.
So Jenny, to make sure I understand my marching orders, from me, you need the most up-to-date iteration, which I should be able to give you hopefully even as early as tomorrow, and then to work with Lyndon on my proposed changes or additions, or leave those out and just let you have the model policy.
So I think that that's a decision for the committee to make. And so
Okay.
we a vote.
Okay.
So typically what we do as a policy committee is we kind of talk through what we want the language to be, and then we go through and we cast a vote on every policy that we have discussed. Sometimes we will be like directing the superintendent. It's like, okay, so take this policy, and we have made some discussion changes, and so we don't literally, you know, wordsmith every piece of it, and we'll say, and the superintendent will say, yes, I understand the changes that are being requested, and I'll make those changes, and then we'll post it in the board book. And so I guess what I'm saying, and I'll put forward the motion, then the committee can discuss it, is that we basically say, I think the easiest way to do it actually is going to be to make a motion that whatever version is ready at the time when Lyndon finalizes the board book be posted as part of the board book of the model policy, and that we get that in place. And again, I think I would leave it to your discretion and your ability to make the changes, Karen. So whatever you feel best represents the work that you have done. I mean, if we can have it with your changes, I would rather do that, even if it's an older version of the model, because I think that you have put so much time and energy into it. I would worry less about, you know, having the latest version from Will, and more about having it reflect all of the work that you've put into it. So whatever version you think is the best version you can put together in time to get in the board book, put that out there, and then we'll have the first reading on that, and then we'll have the actual discussion of it on August 10th. So my motion hopefully will be a more articulate version of that. I guess we also have to figure out which committee members are voting, because we did appoint Liza as a member of the committee. Chuck, are you okay if Liza just stays on and votes on this, or did you want to vote? I don't know how much of the discussion you were there for, because I can't remember exactly.
No, just go ahead. Since Liza was there for the whole meeting, I think it would be more appropriate for Liza to vote if she's willing, and thank you, Liza.
Okay, great. Thank you, Chuck. So should I try to make this motion, or is there more discussion that we want to have prior to that among committee members? I think I wrote this down somewhere. Hang on, let me see if I can find it.
Jenny?
Yes.
I think this is going to be, if you try to make a motion of what you just explained, I think it's going to be a pretty ugly, messy motion. We may want to simply say that we go with the most recent iteration from the SBA, with the understanding that, you know, Karen's put in a lot of work to modify it. We'll get to where we're going, but for now, because of the time frame, it makes sense to use the SBA version to simply make sure that we're in compliance with the law. And we'll, I hate to say it, we'll circle back around, you know, on August 10th.
Yeah.
Okay. I mean, I think that's fine. Here's the wording that I had written down earlier. See if that's consistent with what you think, Gina. So I would be moving that the committee move that the full board consider for first reading the most final draft of the Title IX policy that is available as of Friday. So now, Gina, I'm going to let you do it because you're going to do better. Can you make the motion? And I will, I think you'll be more articulate than me.
I move that the committee recommend to the board for first reading the version of this new policy that is available from the School Board Association, available on Friday, July 30th, with the understanding that we will modify it as necessary to Concord's needs on at the August 10th meeting.
Okay, so you move that the committee recommend to the board for first reading the model policy of New Hampshire School Board Association, the model Title IX policy.
That is available on Friday, the 31st.
On Friday.
Or sooner if I can get it out of Will's hands.
Yeah.
Well, but it would be available on Friday. If you got it out tomorrow, it would still be available on Friday.
Absolutely.
Okay, so Gina's made the motion. I'm going to second it. And now we have some discussion. We have some hands up. And Lyndon has her hand up, and probably that's for clarification of the language, and I think I can read it back. But let's go to discussion, and I will call on Tom.
Thanks, Jenny. So, Karen,
Yes.
did I, at the very first 10 minutes or so, I was not here. So did I miss the fact that a lot of what your policy revisions that you've painstakingly gone through with us tonight were adaptations to the School Boards Association policy?
Correct.
Okay, good.
Kind of the additions too, as is in the adoption notes, additional, more specific in some instances.
And more streamlined to fit Concord's needs.
Correct. Correct.
Okay, perfect. Thank you so much.
Yep.
Great. Thank you, Tom. Thank you, Karen. Lyndon, did you have a question?
Yes, I just typed it in the chat. I wanted to let you know that the new policy will be number 415, following our current 414. Kathleen Murphy and I discussed that today, and I think the policy needs to be numbered and named in the motion.
Okay, so what is it called, Karen, on the draft?
It's called Sexual Harassment Prohibited, Title IX Policy and Grievance Process. Let me say that again, Sexual Harassment Prohibited, and then Title IX Policy and Grievance Process. I think he may have made an alteration so that it says Title IX Policy, I apologize, Reporting and Grievance.
That makes sense.
And I think that what we would do, so that, assuming that we do as a board adopt this on August 10th, it would not replace our current sexual harassment policy. We would have both. It would be belt and suspenders, and then we'd have to go back and reconcile them as part of the work that we've talked about doing. Is that right?
Correct.
Okay. So Tom has his hand up.
Sorry, that was a leftover hand.
Oh, so Lyndon, I think if it's agreeable to Gina, we could add to the motion that it would be policy number 415 and that it would have that title, Sexual Harassment Prohibited, Title IX Reported Grievance Policy. Is that agreeable to you, Gina?
Absolutely.
Okay. And do you have that, Lyndon?
I have that, thanks.
Okay, great. And it's agreeable to me as the second. Is there further discussion of the motion? And I've been getting text from Liza that, so Liza, you were off for a little while. I asked Chuck whether he was willing to have you be the one to vote since I appointed you as a member and you were there for more of it. Are you comfortable with that, Liza?
Oh, there she is, right there.
I see you on mute.
There we go. Okay, sorry, my computer's being a little weird. Yes, I'm fine doing that. Thank you.
Okay, great. So is there any further discussion? Lyndon's hand is up. Do you have something further, Lyndon, or is that over?
No, I'm sorry, I failed to lower it. I will do that.
Okay, so I will call the roll on the motion. Ms. Cannon.
Aye.
Ms. Cannon votes aye. Mr. Croto.
Aye.
Mr. Croto votes aye. Ms. Poinier. Ms. Poinier, I did not hear your vote. Ms. Poinier, I saw, you don't look like you're on mute, but I still did not hear a vote.
Maybe if she goes out and comes back in.
It looks like you're turning your mute off, but I still am not hearing anything.
There it goes. I'm sorry. Aye.
Okay.
Yeah.
Votes aye. Thank you. And Ms. Patterson votes aye. So the motion passes 4-0. So thank you. Okay, so then the only other thing I wanted to do during this meeting was to talk about the schedule and the time frame for the policy work going forward. And I know that we had talked about scheduling a meeting for September. I do not remember. Kathleen or Donna, do you remember what the date was for the September meeting?
I'm sorry, I don't.
I left my calendar in the office, so.
Yeah, calendars are, but I think Lyndon has them, perhaps. That's,
Yeah, Linda, we talked about that.
What are you asking for?
I think it was the 14th or the 16th of September.
Oh, okay. Let me just very quickly look. Hold for a moment. So we're looking for the Communications Committee. We don't have a Communications Committee meeting scheduled for September. There was an instructional meeting on the 23rd.
Well, we talked about it at the scheduling meeting on Monday.
Right. This was what I got from that. Are you sure it wasn't a July? No, obviously not a July meeting. Yeah, I don't have that on the calendar. I'm sorry. I can certainly add it. I can tell you what is on the calendar if you want me to do that.
Okay.
So the board meeting is on the 8th. There's a capital facilities meeting on the, looks like the 14th. Special board meeting for scheduling on the 21st, and instructional, which is an update on the return to school plan, on the 23rd.
So maybe it was the 16th. Is there anything on the 16th right now?
Nothing on the 16th that I received, but I can certainly add that.
I think the 16th, I think we were talking about either the 14th or the 16th. So yeah, let's, if that works for the committee members, let's put that for the 16th. Not hearing any of the committee members protesting. So and I think, I don't want to belabor it because I did spend quite a long time going through the past year's work. So I think my thought is that Gina, you and I can talk and just try and work through with the administrators what is the appropriate schedule for that and what, how we want to, what policies we think we might want to focus on. Does that make sense to you, Gina?
It does.
Okay. Jenny, excuse me, did you want me to put a special board meeting on the 14th? We have a capital facilities committee meeting on the calendar for 5:30 on the 14th. Did you want a special board meeting for this policy vote later
No,
that?
I want for August 10th.
Oh, August 10th, I'm sorry. That's a
Yeah,
Thursday.
Oh, no, it's a.
It's a Monday.
Oh,
Yeah.
sorry. Sorry.
Yes, let's tentatively put this for the 10th. Because again, I guess I'm living in the hope that maybe we won't have to meet this deadline, but let's post it. Let's assume that we're going to have it. I just want to be very clear with the public so that they understand that it's literally just a first reading on the 3rd. We don't want to have people thinking that they have to make public comment on this on the 3rd. And so let's get this so that it's clear that that's a single purpose meeting for the 10th.
And Jenny, will that be at 5:30?
Yes, I can do it at 5:30 if that works for everyone else.
Okay.
Does that sound okay to you, Kathleen?
Yes, it's fine.
Okay.
You know, I look back at my notes for the policy committee and I don't have a date. I'm wondering if we never established it. We talked about a lot of different committees and I just found my notes and I don't have a date, but 16th works great, so.
Yeah, I think we were talking about it being the 14th to the 16th, and then Jim chimed and wanted facilities on the 14th. So in my mind, I was assuming it would be the 16th, but I think we didn't explicitly have that conversation.
Okay, so September 16th.
Okay. Great. Well, this has been good. Thank you again to all of you. Sorry, this has been a confusing meeting, but thanks to everyone who hung in there for this, and to everyone who spent the time knowing that we've got so much other stuff on our plate and another forum tomorrow night. I don't think we have anything else, so I would entertain a motion to adjourn.
So moved.
So Tom has moved. Is there a second?
I'll second.
Gina has seconded. All in favor of adjourning, please indicate by saying aye. Aye. All right. Thanks, everyone. We are adjourned.
Thank you for all your work, Dick, Karen.
Yeah, Karen,
Thank you,
great
Karen.
job. Karen, great job tonight.
Really impressive.
We'll talk.
All right. Have a great night. Bye-bye.
Okay, take care,
Thank you.
everybody.